The Trump administration finally responded to the Supreme Court's Second Amendment Preservation Act challenge, and they continue to argue that the state law is invalid and that the court should deny review. At the same time, they state that they will drop some of the case once it gets back in the hands of the lower court, and this case may now change because some of the political shakeup that has now happened with the Attorney General of Missouri moving in and joining the FBI. So let's break down what is currently happening. Now, before we jump into this Second Amendment topic, I want to address something that's very interesting and I want to bring to your guys' attention. I know a lot of you have followed the channel and you see a lot of the reports and stories and Second Amendment cases and laws that I discuss here on the channel. And maybe you've thought to yourself at one point, how do I avoid making mistakes that maybe cost me my 2A rights forever, cost me a ton of money and time away from my family? And you maybe don't know actually how to protect yourself and avoid becoming another statistic. Now, here's what I can tell you. There is a method, a legal method that I've been using for 6 years that helps keep me and hundreds of gun owners out of handcuffs. It's not legal insurance. It's not carry permits. It's something completely different. This is something that can help protect you even before one of these situations happens. But here's the thing, I've never shared it before. I've never, thought that maybe this is something that people would be interested in. But now I'm, gonna make it available to you guys, and it's only gonna be to a small group of gun owners who understand that staying free requires more than just good intentions. If you're someone who would like to protect yourself and your family instead of gambling with freedom and making huge mistakes, you can click the link down below to be the first to know when I reveal some of these, secrets and information and make it available for you guys. You can sign up for free right now to get, the priority access to this information that will be coming to you guys soon. In this video, we're going to be talking about a significant Second Amendment Preservation Act case that is once again back in front of the Supreme Court. This is a case dealing with the state's Second Amendment Preservation Act, and we've discussed this case and this issue before because recently the Supreme Court issued an 8-1 order denying a stay which would have protected Missouri's SAPA law. This case is now back in the hands of the Supreme Court, and the court will now consider whether they will grant review to a state's Second Amendment sanctuary law or whether they're going to agree with the Trump DOJ. However, some political shakeups caused by the Trump administration may now actually impact this challenge. You might remember that in this case, the Trump administration continued to argue that the SAPA law is invalid in some of its applications and that the Supreme Court should deny emergency review to this case. However, at the same time, they argued that if the court here denies review, if they don't grant the cert petition, the government will release some of the judgments that they received prior once this gets back in the hands of the district court. Missouri responded to this by pointing out that that concession made by the Trump DOJ is exactly why the Supreme Court should grant review to this case, and currently this is heading to the Supreme Court for conference on September 29th. However, this case may now be impacted by some political shakeups because the Missouri Attorney General Andrew Bailey was just elected by the Trump administration to serve as co-deputy director of the FBI. Recently, the Attorney General there, Andrew Bailey, announced that he will be leaving and resigning effective September 8th, and he's now going to serve as co-deputy director of the FBI. That means that before this case gets to conference, the Missouri Attorney General will have resigned, and the case might actually stall out because of those changes, and some things will have to be filed and changed in this challenge. Now, if you're not aware, this lawsuit revolves around a 2021 law, which is the Second Amendment Preservation Act, also known as the SAPA law, which passed in the state of Missouri. That law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies in their attempts to enforce federal laws that violate the Second Amendment. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce those inconsistent violations of the Second Amendment, so essentially federal laws and federal regulations, which the state believes violates the Second Amendment. The law also created a civil remedy where anyone could sue a Missouri official if that official helped to enforce a federal law that the state believes violates the Second Amendment. So the law aimed to give the true enforcement powers to the residents instead of any state officers or agents. Now, in this case, the district court originally on review ruled in favor of the Biden administration, striking down the Missouri SAPA law in its entirety. Now, in response, the state of Missouri then appealed to the 8th Circuit, and Missouri at the time wanted a temporary stay on that lower court ruling. That was denied, and then that essentially led Missouri to seek emergency Supreme Court intervention on this issue. However, on review, the Supreme Court issued an 8-1 order denying that emergency request. Only Justice Thomas was in favor of stepping in early and protecting the Missouri SAPA law and granting the stay that they were requesting. So they denied that, but then this went back down to the lower court and went to the 8th Circuit for a judgment on the case. The 8th Circuit on review ultimately ruled in favor of the federal government, then the Biden administration, striking down the SAPA law once again in its entirety. But now Missouri has filed their writ of cert to the Supreme Court. One of the big issues that Missouri points out is that the 8th Circuit essentially said that the structure and potential operation of this law is valid, but ultimately they struck it down because they did not like the underlying Second Amendment purpose. They did not like that the purpose of this was to protect the Second Amendment. Now, Missouri argues that the 8th Circuit went against clear precedent and found that the state officials could be sued because the court there believed that the state played some sort of role in enforcement, and that role in enforcement was simply complying with the law and not enforcing this, any law that violated the Second Amendment. So essentially there, the 8th Circuit found that compliance and non-action was actual enforcement. Now, this law was originally opposed by the Biden administration, but now the Trump DOJ and the administration has controlled the case. Initially, they stalled out the response for multiple months, but recently we received their answer. And in the response, the Trump administration continues to argue that the SAPA law is invalid and that the lower court got this decision correct. However, at the same time, in that response to the Supreme Court, they said that if the Supreme Court denies review to this case and it gets back in the hands of the district court, at that time, the Trump DOJ will release some of the judgment that the prior administration got because they believe that judgment is too broad and too expansive. They argue in the response that having reevaluated this case, the United States has concerns about whether the judgment below extends too far and enjoins applications of the act that do constitute mere non-enforcement of federal law protected under the anti-commandeering doctrine. And those concerns are exacerbated by the uncertainty in this pre-enforcement posture about how certain provisions of the act will be applied and about whether the provisions on which the 8th Circuit focused is indeed inseparable from the rest of the act. Given these concerns, the United States has decided that it would acquiesce in narrowing the scope of the judgment under the Federal Rules of Civil Procedure 60B when the district court regains jurisdiction over this case. So after stalling this case for a few months, the Trump DOJ has now responded by continuing to argue that some of the SAPA law is still invalid and that the Supreme Court should deny review and just simply kick this case. But at the same time, they essentially argue that they believe the pre-enforcement judgment issued by the lower court went a little bit too far, and therefore they're willing to concede and narrow some of that lower court judgment. Now, in response to that, Missouri argued to the Supreme Court that even if this administration drops some of that judgment down below, the primary ruling of those issues is still valid in the 8th Circuit, and that will remain as precedent and ultimately harm the case as it moves forward. Therefore, the Supreme Court should not punt this case. Instead, they should review, reverse, and do away with what the 8th Circuit said because the 8th Circuit was incorrect in their analysis. This challenge is currently scheduled for Supreme Court conference on September 29th. So at the end of this month, the Supreme Court will hold conference on this. And then usually the following Monday on the order list, we will get some sort of indication of what the Supreme Court decided to do. However, I have a feeling that the conference will be moved, or even if it's held for conference that day, maybe it gets kind of pushed out further, or they move it, to a later date, or they simply just grant what the Trump DOJ wants and they essentially kick the case down below. Now, this is especially in light because of the Missouri Attorney General Andrew Bailey has resigned and he's taking another, co-deputy director role in the FBI. It's unfortunate to see Andrew Bailey actually leave Missouri because I think he's critical in a lot of these 2A cases and a lot of other cases that have made their way out of the state of Missouri. He's been an advocate for the 2A cause, and he's launched a lot of critical lawsuits against, social media companies, China, and all of that stuff. We're already kind of seeing this impact the case because there have been some requests to the Supreme Court to remove counsel, to change counsel for the state of Missouri. There were some filing errors, so it seems like that was not accepted, but it seems like some of the attorneys and some of the staff, of course, with Missouri are having to resign, and maybe they're changing positions as well. So we're seeing that already impacting this case, and this case is probably going to be stalled out, but as of right now, it's still set for conference before the end of this month. I believe on September 29th, there's going to be a conference, and so that's currently what's set. We'll see how the Supreme Court responds after that conference, but this is a critical issue dealing with a state's Second Amendment Preservation Act, and this would be big for other states that want to protect their residents and their 2A rights. So we'll keep an eye on what happens in this critical SAPA case. As we get more information, as it develops more, I will let you guys know. If you like this video, and you'd like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armscholar.com. Over there, we have a lot for you guys: channel merch, coupon deals, all of that. And then also, you can get my free legal guide. All you have to do is put in your email, and we email you over a PDF. And then we do some follow-up emails as well with educational information, coupons, deals, all of that as well. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.